Welcome to the deep dive. Today, we're looking beyond specific incidents to the actual rule book for keeping people safe at big events. We're getting into the Safety at Sports and Recreational Events Act 2 of 2010. And, this thing isn't just about rugby matches. It's surprisingly broad.
It really is. The whole point is making sure people are safe, physically safe, and their property, too, at all sorts of gatherings. We're talking sports, yes, but also recreational stuff, religious events, cultural festivals, exhibitions, organizational things. You name it. And it covers stadiums, specific venues, or even events along a route, like a marathon or a parade.
Okay, let's jump right in. An act this wide-ranging, what's the fundamental idea behind it? What drove its creation?
Well, the preamble itself says it's about promoting and protecting people's rights and safety when they attend these events. But the real core, I think, is putting the responsibility firmly where the control is. It makes sure that the planning, the management, the enforcement, it's all done by people with actual safety and security experience. It sets minimum standards, but also pushes for events to be spectator-friendly and secure.
Okay, so responsibility is key. But with such a huge scope, tiny local festival versus, say, a giant international concert, who exactly has to answer if things go badly?
Yeah, accountability is central. Chapter 2 makes it clear. The main legal duty falls on the controlling body or the event organizer or maybe the stadium or venue owner, one of those. Section 4.1 says they must implement the safety measures laid out and work with the planning structures in the act.
Right.
And there's an interesting legal point, too. If this act clashes with another law on a safety matter it covers. This act usually wins out, Section 2.1. But importantly, it explicitly doesn't apply to gatherings covered by the Regulation of Gatherings Act from 1993. That's a separate thing.
Okay, that clarifies the scope. Now, this is where I find it fascinating. How does the system decide the level of planning needed? You don't want the same bureaucracy for a school fair as for the World Cup final, right?
Exactly. That's where risk categorization comes in. Section 6. Organizers have to send their event schedule either annually or event by event to the National Police Commissioner. And the commissioner looks at it and decides, is this low risk, medium risk, or high risk?
And that rating then dictates everything else.
Pretty much. It sets the level of mandatory planning, the types of certificates needed, the whole operational setup.
So what goes into that rating? How does the commissioner actually judge the risk? Is it just about crowd size?
Oh, it's much more than just numbers. Section 6.7 lists the factors. They have to look at the popularity of the teams or performers, the expected crowd versus the actual safe capacity of the venue's suitability, what security is already there, local crime stats, any specific threat analysis.
Wow.
Yeah, and also the age of the likely crowd, the potential impact of alcohol, even the weather forecast. It's meant to be a really thorough assessment.
A holistic view.
Precisely, taking everything into account.
And what if the organizer disagrees with being labeled, say, high risk?
Good point. There's an appeal process built in. The Act sets up an independent appeal board. Section 26. You can appeal against the risk category or decisions about safety certificates, prohibition notices, exclusion notices, basically the key enforcement decisions.
Is a board just police again? Or?
No. It's designed for independence and expertise. Members need special knowledge in event safety, security, disaster management. And crucially, at least one member has to be a practicing lawyer with experience, and they chair the board. So there's legal oversight.
Okay, so risk is assessed, maybe appealed. What happens next? The actual safety paperwork. You mentioned certificates.
Yes. Once the risk level is set, you need the right safety certificates. Think of this as the infrastructure check. Section 7 lays this out. The local authority, the municipality, handles the physical space. They issue things like an existing stadium or venue safety certificate. That needs renewing every year. Section 8.
Annually.
Yes. And then there are certificates for new stadium or venue designs, Section 9, or if major alterations are done, Section 10. And very importantly, the local authority gives the venue a grading certificate. That determines the absolute maximum safe number of spectators allowed.
So the local authority checks the building is safe and says how many people it can hold. What about the specific event's safety?
Right, that's the next layer. If the event is categorized as high risk, the National Commissioner then issues a high-risk event safety certificate. Section 11, this is event-specific. It might include conditions like extra security measures or limits on when tickets can be sold.
Got it. Infrastructure certs from the local guys, high-risk event cert from the police commissioner. Now, how does this translate into action on the day? Who's actually in charge?
For medium and high-risk events, it mandates a formal structure. First, the National Commissioner sets up an Event Safety and Security Planning Committee, the ESPEC, Section 15.
The planning team you mentioned.
Exactly. It's chaired by a senior police official, captain or above. This committee writes the detailed safety and security plan for that specific event. Evacuation, medical, communication, everything.
And then coordinating it all during the event.
That happens from the Venue Operations Center, the VOC, Section 17. Think of it as the nerve center, the command post for the whole safety operation on the day. It's mandatory for medium and high-risk events.
And who's in the VOC? Just police running the show?
No, definitely not. That's a key aspect. The VOC must have representatives from all the key players. Police, absolutely. But also disaster management, the private security company involved, emergency health services, the fire department. They all have to be there.
So everyone's in the same room, coordinated.
Yes. And there's a designated VOC commander, again an authorized police official, who ensures that written plan is followed and coordinates the real-time response. It makes accountability very clear.
Let's switch gears to the attendees, the spectators. How does the act manage them right from buying a ticket?
Okay, several important parts here. First, event ticketing itself, Section 19. The absolute rule is the total number of tickets sold plus any comps or written permissions cannot go over that certified safe spectator capacity from the grading certificate, no exceptions.
What about ticket touts, scalping?
The Act tackles that too. Section 5.2 prohibits unauthorized resale of tickets for commercial gain. It's aimed at stopping organized scalping.
And controlling who goes where inside the venue.
That's handled by accreditation, Section 18. For specific zones like VVIP areas, media centers, operational areas, you need formal accreditation. Trying to get into one of those areas without the right pass is actually an offense. You could face a fine or even up to 6 months in jail.
Okay. And what about dealing with potentially troublesome people before they cause a problem?
Yes, the Act gives preemptive powers. Two main tools. First, the National Commissioner can issue a prohibition notice, Section 21. This can restrict or even completely ban people from entering a stadium or venue if there's a serious risk to safety or property. It's a preventative measure for potentially large-scale issues.
And the second tool?
That's the Spectator Exclusion Notice, Section 22. This is more targeted. The authorized police member or the VOC commander can issue this to a specific person or even a group if there are reasonable grounds to believe their presence could lead to disruption, injury, or damage. It's about intervening with specific individuals or groups identified as risks.
And to back all this up, what powers do officers have at the gates? Searches.
Absolutely. Section 20 covers searches and seizures. Authorized peace officers can search anyone entering, their vehicle, bags, containers, whatever, looking for specific prohibited or restricted items, weapons, fireworks, excessive alcohol, that sort of thing. If you refuse a search or if you seem intoxicated, they can refuse you entry or ask you to leave. And possessing a prohibited item inside the venue or along the event route is forbidden.
Okay, this framework seems incredibly detailed, which brings us to the consequences. What happens if an organizer just ignores all this, cuts corners on security staff, doesn't bother with the planning committee, oversells tickets? What are the real teeth in this act?
And the teeth are sharp, extremely sharp. Section 44 details the offenses and penalties. If you organize an event completely ignoring the act, or you fail to comply with the core safety requirements, like having enough trained staff, following the safety plan, you could face a hefty fine or imprisonment for up to 20 years.
20 years for basically a safety management failure. That's huge.
It is. It really highlights how seriously the law views the responsibility for public safety at these large gatherings. It's not just a slap on the wrist.
Puts personal liability right at the forefront for organizers.
Absolutely. And there are other serious penalties, too. Things that directly affect the experience inside. Engaging in what the Act calls delinquent and antisocial behavior, and it specifically includes using racist, vulgar, or obscene language. Or ignoring a prohibition notice, or illegally reselling tickets, those can lead to fines or imprisonment for up to 10 years.
10 years for bad behavior or ignoring an order. Wow.
It sends a clear message about expected standards, both for organizers and attendees.
So pulling it all together, this act really seems like a comprehensive, multi-layered system. It goes from the concrete foundations of the stadium right down to individual spectator conduct.
It does. It moves way past just having police present. It demands formal planning, documented procedures, certified venues, and real coordination between everyone involved: owners, authorities, police, emergency services. It's fundamentally about proactive risk management, not just reacting after something goes wrong.
So for you, the listener, what does this actually mean when you're heading into a big match or a concert?
It means that feeling of relative security you have isn't accidental. It's mandated by this law. Behind the scenes, there was a required risk assessment. The venue has safety certificates. There's a written safety plan, even for low-risk events. Section 4 fine requires one. And for bigger events, that VOC, that multi-agency command center, is operating, coordinating everything. Your safety has been planned for, legally required.
Okay, a final provocative thought to leave everyone with. We've seen the strict requirements, the need for certified structures, detailed plans, potentially huge security deployments, and that mandatory public liability insurance in Section 25. Think about the sheer cost of all that compliance, the engineers, the expert staff, the insurance premiums, the technology for the VOC. How much does the legal necessity of safety fundamentally shape not just the ticket price, but whether some events are even financially viable to stage at all? Compliance isn't optional, and it certainly isn't free.